Okay, that's enough time. We'll make a start. Thanks for joining today. This is my 7th of these brown bag sessions on international maritime security law. Today, I'm covering hot pursuit and the use of force. Quite a lot to cover today. I'll be starting with the doctrine of hot pursuit and where this is incorporated into the UN Convention on the Law of the Sea, Article 111. And then I'll touch briefly on what domestic New Zealand legislation says about how this applies in our circumstances. I'll move then to the use of force. An interesting feature of this part of law is that it's not incorporated into UNCLOS, so we rely more on state practice and customary international law and what bilateral treaties say about how this part of the law works. So I'll talk through that. And then I'm going to touch on the UNODC, United Nations Office on Drugs and Crime, Maritime Crime Manual, which is a bit of policy description of this part of law. Usual health warnings apply. This is a session for me to pass on what gets taught at the international level by the IMO, particularly for any operational people who have different understandings of what New Zealand's practice is here. In fact, I would not just encourage, but insist you have something to say at the end that'll be interesting to talk about. But please do hold your questions until the end. This is a session that's recorded because it's unclassified, so we can pass it around if there's anything you miss. So we're going to start with hot pursuit and Article 111 under the UN Convention on the Law of the Sea. Just a bit on what this doctrine actually means. What are we talking about with hot pursuit? So to start with, this is what happens when a ship fails to heed an order to stop and submit to whatever an appropriate law enforcement action might be, given by a coastal state authority, where that authority has good reason to believe the ship has violated the laws and regulations of that state. So there's a picture I've stolen off Google that should spell out broadly the process. Where there's good reason to believe that a law has been violated by the coastal state, a hot pursuit may be initiated if it's commenced when the suspect vessel or one of its boats, and keep that concept in mind, there's this sort of mothership, daughtership concept that gets quite interesting here. When the suspect vessel or one of its boats has violated the regulations or laws within a coastal state's maritime zone, the right of hot pursuit may be exercised by government vessels only, so vessels on government service, typically warships or Coast Guard, that are authorized and described to that effect. Typically, you paint it grey and put a number on the side. Now, the significance of a hot pursuit is if it's done correctly and it leads to the successful interdiction of a suspect vessel, it preserves the coastal state's law enforcement jurisdiction over that vessel, even if the vessel has moved out of the zone where the initial offending occurred. So the jurisdiction travels, right? So without Article 111, if an offence occurred, for example, in the territorial sea within 12 nautical miles, and then it gets beyond 12, it gets away scot-free. What hot pursuit allows you to do is to take that jurisdiction with you. So that's the concept. What I typically like to do in these presentations is show the articles from UNCLOS verbatim. Article 111 is about half a page, so I'm not going to do that for this one, but there's some key elements there that I've pulled out. To start with, it's of a foreign ship, which is pretty obvious. If it's your flagged vessel, you have exclusive flag state jurisdiction anyway. So this is a doctrine that applies to foreign ships. The coastal state needs good reason to believe that an offence has occurred. So there's often an evidentiary standard, particularly for that legal finish piece, if they want to conclude a prosecution to demonstrate that an offence has actually occurred. And it's a violation of whatever the coastal state's laws say in a different jurisdictional zone. So on that jurisdictional zone, the hot pursuit begins when a foreign ship or one of its boats is within the internal waters, archipelagic waters, territorial sea, contiguous zone, or exclusive economic zone of the coastal state. So pretty much anywhere on that box on the left. Pursuit of a foreign ship within the contiguous zone, which is 12 to 24 nautical miles, may be undertaken for violation of fiscal customs, immigration, or sanitary laws. And that's because those are the enforcement powers UNCLOS gives coastal states within that contiguous zone. And that applies also in principle to regulations in the exclusive economic zone. So it's very much a zonal approach. What about beyond the exclusive economic zone? So that box on the right. If you attended the piracy presentation, you'll recall that piracy is beyond 12. If it's within 12, it's armed robbery at sea. It's not legal, but it's just not piracy in terms of Article 100 for UNCLOS. I did also mention in that presentation this idea of reverse hot pursuit. So hot pursuit under Article 111 is designed for traveling out of your jurisdiction. For piracy, it's traveling in from the high seas into a coastal state's jurisdiction. However, if the vessel makes it into its own flag state's territorial sea or that of another coastal state, the pursuit has to stop unless there is coastal state permission to continue or a United Nations Security Council resolution. I have previously mentioned UNSC 1816, which was for Somalia's territorial sea. So hot pursuits and boarding were permissible under that authority. Another concept that's quite interesting here under hot pursuit is this concept of constructive presence. And the way this works is that a foreign vessel is treated as if it's located in the same place as another craft with which it's cooperating to commit a crime. So this is the mothership and daughtership concept. An example of how this might play out is, for example, a fishing boat that's illegally fishing in a coastal state's exclusive economic zone, travels out of the exclusive economic zone to meet up with another vessel on the high seas and transfers that illegal catch to that second vessel. Constructive presence says you can construe that mothership that never came within the exclusive economic zone to have been constructively present within that jurisdictional zone so the laws can then apply. And that's true of any of those jurisdictional zones. What's important here, though, in that last bullet point is you need good evidence that the two are working as a team. So enforcement officials might want to observe them to establish that evidence base, whether it's AIS tracking or radar or satellite imagery that displays certain behaviors that give good evidence these two are working together. Constructive presence means you can get quite creative. Further on Article 111, a hot pursuit can only start after a visual or auditory signal to stop has been given by the law enforcement officials, and it has to be done at a distance which enables it to be seen or heard by the foreign ship. So there has to be an element of good faith that's demonstrated here. What that might look like in practice is something like flares, sounds, lights. You might have particular maneuvering procedures that make it very clear you're trying to get the full attention of the master and crew of that vessel. You could also just contact them locally on VHF channel 16 and instruct them what your intentions are. An example of what instructions here might be, the captain of a vessel might identify the vessel, name it, identify themselves, and then say, Captain, it does not appear that you are responding to my directions. Please comply now. If you do not understand my instructions, please tell me now and I shall repeat them. And you can repeat that as many times as it takes to make it clear that it's been seen or heard. The pursuit can be continued outside a specific zone as long as it's not interrupted. And I'll elaborate a bit more on what not interrupted means in a bit, but you need a sustained visual or electronic means to continue the hot pursuit. There's no requirement that the ship that gives the order to stop is within that zone where the offence is committed in the first place. And finally, the hot pursuit stops, as I said, as soon as the vessel gets within the territorial sea of another state or its own flag state. Here's what this looks like for New Zealand. We have a Maritime Powers Act. Section 6 talks about pursuit without interruption. So we don't call it hot pursuit like UNCLOS does. I don't know why. I suspect hot pursuit sounds too American, and calling it pursuit without interruption makes it really clear what the legal requirements are, right? So you can see here, Section 6, a ship is pursued without interruption if, and then it gives these 5 limbs. First, the person in charge of a ship, a suspect vessel that's being required to stop by an enforcement officer doesn't stop. Second, the enforcement officer or the person who communicates that requirement to stop has given that visual or auditory command to stop, and has made a good faith effort to ensure that it's been understood, or at least that they're aware of it. But then if you come down to Section 6.2, it actually says the command to stop is still considered as complete, even if it's not understood or the suspect vessel isn't aware of it. So it doesn't need to be apprehended on the other end as long as the enforcement officer has made a good faith effort to communicate it. That is considered as communicated. Third, that requirement to stop is not complied with. The ship is then pursued from that place. And you have to love this, Section 6.1e, a ship is pursued without interruption if the pursuit is not interrupted. Nice. Section 6 does actually go on to explain what not interrupted means, though. And you have, I'll just pause there, go back a second. These elements are all cumulative, by the way. You'll see the word "and" at the end of each clause. So all of these things need to happen for it to be a successful pursuit without interruption. This list, however, these are conditions under which a pursuit is not considered interrupted under our legislation, and it's quite permissive. So if the pursuit is continued by an enforcement officer who is other than the person who communicated the initial instruction to stop, so it doesn't have to be the same person who says stop who conducts the pursuit. The pursuit can be taken over by the ship or aircraft of another state or of your state's other ships or vessels. That will continue a pursuit. It can be continued by the ship or aircraft of another state without your enforcement officials on board. So quite expansive jurisdiction. If the vessel goes beyond the line of sight of any of your officers, and if it is not trackable by electronic means. So pretty expansive, right? It doesn't have to look like that the whole time. It can be quite expansive. The longest one I know of, by the way, 2003, the Australians pursued a Uruguayan vessel for 3 weeks. They got just about to South Africa. They traveled altogether something like 7,500 Ks, 4,000 nautical miles. So it can take a while and it can go long distances. Just finishing off Article 111 for hot pursuit. Again, as I said, it's exercised by vessels on government service. They're going to be clearly marked and authorized for this purpose. But what happens when you catch them? So hot pursuit doesn't require that the use of force happens, but this is typically where this activity might happen. Under one of my previous presentations on the right of approach and visit, that's Article 110 of UNCLOS. Hot pursuit is Article 111. So you can see there's deliberate sequential inclusion of those provisions in UNCLOS. Under the use of force, this is different to hot pursuit in that it's not incorporated into UNCLOS. We rely on customary international law, state practice, bilateral treaties or other documents to learn what this area of law actually entails. The general principle across states is that coast guards or whatever constabulary function a state uses will authorize and empower law enforcement duties for these agencies. Obviously, we don't use our Coast Guard for that. The level of force is not set in black and white. It's going to be very circumstantial and depend on the context in which it's used. So, for example, it would be assumed that illegal drug operations or counter-piracy might carry with them a higher expectation of the use of force on the part of enforcement officers, whereas something like a fisheries operation or protection of the marine environment would be less so. Now, Professor Douglas Guilfoyle of the University of New South Wales uses evidence of violence against Australian fisheries officers to say that the assumption that fisheries operations would carry a lesser expectation of the use of force is mistaken. So that just demonstrates that it's not clear. It's going to be circumstantial and contextual. The bottom line, and this is, I guess, a through line that applies to all states, is an expectation that the force used is, in the circumstances, reasonable and necessary. So those are the two things that will be applied as a test. So two types of use of force. There's a use of force before boarding, and then there's a use of force during a boarding. I spoke about the need for clear auditory and visual signals that are given. The way that might work, and there's actual templates you can use among states for how this is done. So to read off one of them, I gave you an example of a verbal command given to stop. If that isn't complied with, what then might be said is, again, you'd identify the type of vessel. If you refuse to stop and permit us to approach and board, we shall fire across the bow of your ship. Do you understand? So being very clear about your intentions. If that is not complied with, the next instruction might be, Captain, your failure to comply means we must disable your vessel. We shall disable your vessel by firing at the stern. I am now giving you an opportunity to evacuate your people from the stern of your ship. You are putting yourself and your crew in great danger. Do you understand? If that, after repetition, isn't complied with, the next instruction might be, again, you'd name the vessel. That was your last warning. If you do not stop your vessel immediately, the next round shall be fired into your stern. Do you understand? So pretty clear template to follow. If the vessel is then boarded, this is a kind of example of the policy that might be used, a general assumption that the minimum use of force will be applied at all times to compel compliance, nothing more than what's reasonable and necessary in the circumstances. Broadly, you have this sequence of the levels of use of force. You'll start with officer presence, so your sort of physical command. You might use gestures, verbal and visual commands, and so on, up to eventually the use of deadly force if necessary. You don't need to hit all of these in sequence. You just apply the one that's necessary in the circumstances, again, with that assumption that it's always going to be the minimum amount required to compel compliance. In the circumstances, what is used will be assessed on what's reasonable to a person in the shoes of the enforcement officer using that violence or that use of force. It doesn't have to be 20/20 hindsight, what we think after the fact. It's what is reasonable to an officer in the circumstances. So the way we got there is through about 100 years of, I guess, international case law. I'm going to talk about 4 cases that have crystallized into the general principles as we understand them now. The first case is from 1929. It's the I'm Alone. This was a UK registered ship, which was a rum runner during the alcohol prohibition era in the United States. The I'm Alone was acting as a mothership in this scenario, carrying rum from Belize down to the Gulf of Mexico, where the rum was then offloaded onto daughter ships that would then smuggle it into the United States. And at this time, the UK and the US had a bilateral agreement among themselves whereby the US was authorized to board and search vessels suspected of smuggling liquor. So the I'm Alone was one such vessel, intercepted by the revenue cutters Dexter and Wolcott. So USRC here is a revenue cutter, so a customs vessel of the day, basically. They engaged in a hot pursuit of the I'm Alone for 2 days. She was given repeated orders to heave to for reporting. Warning shots were fired and then eventually disabling fire. The revenue cutters decided they'd had enough of this dispute and then they just sank the vessel intentionally. So there was a claim commission stood up between the UK and the US, and they found that the act of intentionally sinking the vessel wasn't justified. So to narrow down on what the legal question was here, the issue was whether in those circumstances the US was justified in sinking the I'm Alone. And the answer from the commission was the US could legitimately use necessary and reasonable force to achieve the objective of seizing and boarding the vessel. And if incidental to achieving that objective, the vessel sank, that would be legitimate. But because the intentional sinking was the objective, that wasn't reasonable in the circumstances. So you can see they're setting some parameters here that you can still accidentally sink it as long as the use of force is reasonable to the attainment of some other objective. Next is the Red Crusader. So she was a British trawler, that's her at top right, who was illegally fishing near the Faroe Islands, intercepted by a Danish frigate, the Niels Ibsden. The skipper initially obeyed the instructions given to him to follow, but then attempted to escape while 2 Danish sailors were on board. So the Niels Ibsden ordered the Red Crusader to stop, fired 4 warning shots, but she refused. So then Danes went all out. They fired at the radar scanner, the mast light, and the hull without warning. So the initial warnings to stop were verbally conveyed, but then all of these shots came without warning. The vessel wasn't sunk and no one was injured, but there was still an Anglo-Danish Commission of Inquiry which looked at this and found that the captain had exceeded the legitimate use of force in these circumstances for 2 reasons. First, had fired without warning, and second, he unnecessarily created an endangerment to human life. Even though no one was injured in this case, life was unnecessarily endangered. And on the facts, the commission found that other means could and should have been attempted first, that if they had been persisted in, might have caused the vessel to stop. So next we have the Saiga, and this one gets cited all over the place. This is pretty much as bad as it gets. The Saiga, up top right, she's an unarmed tanker providing bunkering services to fishing boats. So if you're following the hint here, we have a mothership situation. She was attacked by Guinean patrol boats who fired with live ammunition from large caliber automatic weapons. They boarded the vessel and arrested it on the high seas for alleged violations of Guinean customs laws. So we have the constructive presence doctrine that was applied here between those fishing vessels and the bunkering vessel. Now, the officers boarded without any resistance from the crew, but they started firing indiscriminately while on the deck and shot into the engine to disable it, causing considerable damage to the engine, the radio room, and severely injuring 2 people. So the International Tribunal for the Law on the Sea, the kind of judiciary arm of UNCLOS, saw fit to restate what the customary practice here was for approach and visit. Must first use an auditory or visual signal to stop, which they didn't do in this case. And where that doesn't succeed, start with a shot across the bow. They didn't start with that. And the use of force must be a last resort, whereas in this case, it was kind of the first resort. And this is what they found. The Ghanaian officials had used excessive force and endangered human life even before they boarded, but certainly while boarding. International law requires that the use of force must be avoided where possible, and even if it's unavoidable, mustn't go beyond what's reasonable and necessary. There you go, those words again. And the use of weapons by the boarding party in this case was excessive, given there wasn't any resistance from the crew. So this is always held up as a case of what you don't do. But a boarding done well, more recently is the Virginia G. She was providing gas oil to fishing vessels in Guinea-Bissau's exclusive economic zone. She was approached by speedboats that were clearly marked as government vessels and were boarded by uniformed FISCAP and Navy personnel. So FISCAP, Spanish acronym, I won't attempt it, but it's sort of the Fisheries Enforcement Agency. And you can see they're clearly marked in those pictures there. They took control of the vessel and ordered the captain to sail to the port of Bissau for further investigation. Panama disputed what happened here and said that the officials who boarded didn't identify themselves. They were intimidating by brandishing weapons. They confined the crew at gunpoint, even though the crew weren't resisting. And they prevented the captain from communicating with the ship's owner. ITLOS found this. The patrol boats used by the officers were clearly marked, as is required. The boarding party were dressed and clearly identifiable as a boarding party with lawful authority. In the initial stage of the boarding, the captain was actually permitted to communicate back with the ship's owner, and the use of force didn't go beyond what was necessary in these circumstances. So although the weapons were drawn, they weren't fired, there were no injuries or endangerment of life. So this is basically how you do it. So that's the case law as it is, and that's kind of crystallized into a number of treaties. I'll just touch on these briefly. One of them is the UN Fish Stocks Agreement. So Article 21 under this, we're a party to this agreement. This is a UN treaty. It allows boarding and inspection to happen, and then Article 22 sets those limits around how use of force occurs. You can see again that wording is proliferated throughout here as well, when and to the degree necessary, and to the extent that it's reasonably required. The SUA Convention, suppression of unlawful activities. I won't spell this one out. I have a separate presentation in a couple of months on this. But again, you can see the similar language, necessary and reasonable use of force should be avoided where possible. And then it actually goes to spell out some more detail on boarding party conduct. Interestingly, spells out the attention that needs to be given to international human rights law and the dignity of the crew by the boarding party. Next, the 1988 Vienna Drug Convention. This in itself doesn't give any use of force rights, again, because it's strictly a United Nations construct. They kind of avoid that. But what it does do is call for states to enter into bilateral treaties where they will set up kind of advanced consent for boarding and the use of force. New Zealand's a party to this one. Next, the Proliferation Security Initiative, not a treaty, but New Zealand participates in this, set up by the United States after 9/11 for the tracking of WMD and their components. And so participating states under this are expected to coordinate either operationally or with bilateral treaties on the use of force. And finally, the UNODC Maritime Crime Manual, not a treaty, not law, but policy. I have a copy here if you want to take a look, or it's online, noting that the use of force for these purposes is a peacetime mission, not wartime. So it kind of sets that ceiling on what the use of force will look like. Noting that agents may use force in self-defense, again, what's reasonable and necessary for the attainment of a specific task. And then spells out what deadly force might look like as well. Okay, I think I'll leave that there for you guys to research yourselves. I'm well over time. So what I've discussed is starting with hot pursuit, what this looks like under Article 111, what New Zealand's treatment of it is in Section 6 of the Maritime Powers Act. Again, if you want a copy of, actually, I don't know if I did mention, I led the development of some decision support tools on that Maritime Powers Act. Unfortunately, it's restricted, so I can't share a copy here. But if those of you working in this space want a copy, get in touch with your agency leads. So I know Defence, NZDF has one, MFAT, Customs, Police and DOC. Get a copy from them, or I can send one if you get in touch with the Secretariat. Next, I discussed the use of force, how this was developed through a number of cases and then crystallized into some provisions in international treaties, and then very briefly touched on some policy in the UNODC crime manual. Way over time, but happy to stay for questions if people have any.
Evan had a question online about can you use drones as part of uninterrupted? I'll assume.
To the extent they are considered vessels on government service or are an extension of SAM. Nice. I obviously covered it all. Okay, next. Further from Gavin.
I was just going to say thank you, Josh, as ever. Awesome presentation. What's next?
Autonomous vessels on the 10th of September. See you there.
Thank you.
Thanks.